The appeal court confirms jet-setting couple with separate residences were still living together. In a follow-up to our recent blog about a 2019 decision about a wealthy man and former model, the Ontario Court of Appeal has recently issued an important confirmatory ruling in the matter. Factually, the case involved a romantic relationship set against an extravagant and jet-setting lifestyle. Legally, the case examined the important and broad-reaching issue of what constitutes a common law spouse under the Ontario Family Law Act. The appeal court stated the issue this way: where the parties had a long-term romantic relationship, never married, do not have children together, and chose to maintain their own homes rather than live together, was the time they spent together sufficient to amount to living together in a conjugal relationship. The couple started dating back in 2001 when the man, who was very wealthy, was 46 years old. At that time, the woman was a 38-year-old model earning about $60,000 a year. Within a month of dating, the man started giving her monthly allowance plus access to his credit cards. He paid for many of her everyday expenses, took her on extravagant holidays, and bought her gifts, 7 fur coats, and her cosmetic procedures, among other things. Most summers were spent at the man's cottage and most winters at his Florida condo. Importantly, they never lived together, but had separate residences a few blocks away. They parted ways almost 14 years later, which prompted the woman to bring a claim for spousal support on the basis they were common law spouses, as defined by the Family Law Act. The man asserted the woman was just a girlfriend and a travel companion, nothing more. The woman claimed that he had proposed marriage to her several times, treated her as his wife, and among other things gave her a 7.5 carat engagement ring, a wedding band, and an eternity ring. The women believed they were married for all intents and purposes, but for participating in a ceremony. The crux of the legal dispute between them derived from the statutory test for common law spouses in Ontario. It required that they must have cohabitated, a term defined to mean live together in a conjugal relationship. In this case, the definition was problematic because they each had kept separate residences throughout the nearly 14-year relationship. At trial, the judge gave detailed consideration to many aspects of the couple's marital, social, and sexual relationship and found that they were in a long-term committed union. After much reflection and noting that there was no bright line rule, the trial judge ultimately concluded that the couple's extended time together at the cottage and regular periods of part-time living together qualified them as cohabitating for the purposes of the Family Law Act's spouse definition. On appeal to the Ontario Court of Appeal, the court confirmed that specific aspect of the trial judge's fact-based ruling. The Court of Appeal wrote that that trial judge had correctly interpreted the legislation and articulated the governing legal principles in deciding whether the parties had been spouses. The court had been pointed to no errors in her factual findings, much less ones that were palatable and overriding. In effect, on this ground, the man asked the court to rewrite the evidence, that is, to apply the law to the facts and come up with a different result, that of the trial judge. But that is not the role of the Court of Appeal. Absent reversible error, the Court of Appeal must defer to the trial judge's application of the law, to the facts as she found them. On the other hand, the Court of Appeal found the trial judge did err in her legal analysis of when the living together phase has started, which error affected the spousal support that the woman was properly entitled to. Look for our blog on this subject. If you like this video, you can please share it. You can subscribe by clicking the bell at the bottom of your screen. You can also comment by leaving your comments in the box below. We're going to endeavor to answer everyone's comments at the end of each week. Thank you for watching today. I'm Russell Alexander.